When a borrower defaults, what happens next? In California, the rules protecting debtors are well known. But what about the rights of the creditor? Banks and credit unions have important legal tools at their disposal, but only if they're used correctly. Hi, I'm Christina Carter, a financial industry lawyer here in California. I work exclusively with banks, credit unions, and businesses, not the general public, to make sure your creditor rights are enforced and protected. Today, I want to walk you through creditors' rights in California, what you need to know, and how you can avoid costly mistakes when pursuing debt collection. If your institution is navigating collection or bankruptcy, or you are concerned about compliance with California's expanding debt collection laws, this video is for you. First, let's talk about the laws that apply. At the federal level, we have the Fair Debt Collection Practices Act. California takes things further with the Rosenthal Fair Debt Collection Practices Act. Unlike the federal law, the Rosenthal Act applies directly to original creditors, including you as the financial institution. That means your collection activities must follow the same restrictions that debt collectors face. So let's break down what you, as a bank or credit union, are actually allowed to do under California law. First, you can absolutely send written communication, but here's the catch. The outside of that envelope can't say anything that tips off it's about a debt. Why? Because California law protects a borrower's privacy. Even something as simple as the word collections on the outside could get your institution in trouble. Second, phone calls. You can reach out between 8 a.m. and 9 p.m., a window that's designed to be reasonable hours. But you can't call someone at work if you know their employer doesn't allow it. Again, this is about striking a balance between your right to collect and the borrower's rights not to be hassled. Third, negotiation is always on the table. Many debts get resolved through a structured settlement or payment plan, and that can save you both time and resources compared to litigation. Now, if negotiations don't work, you can file a lawsuit. Once you obtain a judgment, that opens the door to powerful enforcement tools, such as placing liens on property, garnishing wages, or levying bank accounts. Each of these has limits, but they can be highly effective in recovering what's owed to you. And finally, if you're a secured creditor, say with a mortgage or auto loan, you have rights to the collateral itself. That could mean foreclosure or repossession, depending on the type of the loan. These remedies are built into the contract, and California law recognizes your right to use them. Now let's flip the coin, what you cannot do. This is where a lot of institutions get tripped up. Harassment is strictly off limits. That means no abusive language, no repeated calls just to annoy the debtor, and no threats of violence. You also can't use deception, like misrepresenting the balance due, pretending you're someone you're not, or implying you're affiliated with the government when you're not. And when it comes to third parties, the rules are crystal clear. You can't share details about the debt with anyone else, except in very limited situations to locate the debtor. You can speak with a spouse, but you can't start telling friends, neighbors, or employers about it. Violating these rules isn't just bad optics. It can open your institution up to lawsuits, penalties, and reputational harm. That's why compliance isn't optional, it's critical. Beyond the day-to-day rules, there are bigger strategic factors every financial institution should keep in mind. First, know the difference between secured and unsecured debt. Secured creditors, like mortgage or auto lenders, have the advantage of collateral. Unsecured creditors don't, so they must go through the court system first to collect. Second, as of July 1, 2025, California's Rosenthal Act expanded to cover certain commercial debts up to $500,000. That means even some business loans are now subject to consumer-style protections. If you lend to small business owners, your compliance processes should already reflect this change. Third, think about bankruptcy. A Chapter 7 case is very different from a Chapter 11 or 13 case, and your rights depend on the type of debt and how you handle your filings. Filing proofs of claim, seeking relief from stay, or pursuing non-dischargeability actions can make a huge difference in how much you ultimately recover. And finally, never underestimate the importance of keeping accurate records. If you can't prove the debt, You may lose your right to collect. Here's an example. A California credit union recently attempted to collect on a commercial loan without realizing the RFD-CPA changes were about to cover that type of debt. They risked exposure to litigation simply because their compliance systems weren't updated. With experienced creditor counsel, the process would have been handled properly, protecting their rights while staying within the law. That's where I come in, to make sure your institution is shielded from liability while maximizing your recovery. Here's the bottom line. Creditors have rights too, but in California, those rights come with strict rules. If you're a bank, credit union, or business lender, you need someone who understands both the protections debtors have and the remedies still available to you. At Western Law Corporation, we represent creditors nationwide, but California is where these issues are especially complex. If your institution requires assistance with collections, foreclosure, or bankruptcy representation, please reach out today. I'm Christina Carter, and I'm here to protect your rights as a creditor. Let's make sure your institution is compliant, strategic, and positioned to recover what it's owed.